Chairman.
Thank all of our testifiers. Really extraordinary testimony. All of you deeply professional, deeply knowledgeable, obviously not in agreement. Some intense frustration expressed. I respect that. These issues, as I said before, are foundational to people's identity, to communities, to tribal identity. And so I just wanted to acknowledge the professionalism with which you all delivered your testimony. I'll start with Mr. Newland. I understand the department is currently gathering data related to freedmen eligibility for certain federal benefits. Can you just talk a little bit more about what's going on in that process and how it's coming along?
Thanks, Mr. Chairman. So as I mentioned in my testimony, we had conducted consultation, formal government-to-government consultation with the 5 tribes back in February. We received, in addition to sitting down and having a conversation on some of these same issues, we received comments. And the question was whether to admit non-tribal member freedmen descendants as students at Haskell and SIPI. One of the challenges with that is that the BI is not currently set up in a way where we have the capacity to make determinations about who would and would not be eligible. We typically rely upon tribal governments for membership and citizenship questions. And so we haven't yet decided on definitively on a course of action coming out of that consultation, but those are some of the issues that we were considering.
Got it. So I'm sort of assuming you can't answer this question, but based on the data that you're gathering so far, do we have a ballpark number of how many freedmen descendants have equities across the 5 tribes?
I don't have that number, Mr. Chairman.
Thank you. There's been talk, Ms. Van's testimony talked about a CRS report. There's been talk among staffers about a GAO report, and just cards on the table as I'm thinking about the path forward. That strikes me as an important first step, just to sort of set a baseline of how each of the 5 tribes are in a different situation, both in terms of their treaty obligations, but also their current view of the issue and where they may or may not be in pending litigation. But also some baseline data about how many people are we talking about, right? What percentage of the current roles would this constitute? What kind of resource requirements would that implicate? And so I'm wondering what your thoughts are about a GAO report to try to get a level set here about the history, the legal aspects, the mechanics of conducting a role. I know something about this from the Native Hawaiian community, the blood quantum questions, the lineal descendancy, they're not so easy to settle. And so even before you get to the potential for public policy in this space, you need to know what the facts are. And so I'm wondering what you think about that.
Mr. Chairman, we would be happy to work with the committee to and better understand kind of how that study would be set up. But you hit the nail on the head that simple descendancy does not, in and of itself, doesn't necessarily mean that somebody would be an eligible freedman descendant, because each tribe has slightly different citizenship requirements. And so the short answer to your question is we'd be happy to continue those conversations to look at how we would better define the universe here.
My final question before I turn it over to Vice Chair Murkowski, and I'll do a second round to try to ask some additional questions. Chief Hoskin, you testified that the nation has approved and processed just under 12,000 citizenship requests. Do you have an idea of, was it an initial rush and now you just have a few coming in the sort of regular order, or are there a lot of requests still pending for processing? How is this working?
There was an initial rush because of the obvious news of the court decision and how we embraced it, but the number has grown steadily. So when I testified before a House committee earlier this year, we were somewhere in the neighborhood of the 8,000 range. And so that gives you an idea. Now we're closing in on 12,000. Now we are the largest tribe by population in the United States, coming on to 440,000 citizens in that neighborhood. I think as we go out and engage in our outreach, Mr. Chairman, we are encouraging more people to sign up. And it's a rigorous process, and it should be, but we are doing outreach, and I think that's why you see our numbers continue to grow. I don't know what the ceiling is, and I don't know right now, although we can get the committee this information, what our pending applications are, but we process thousands of applications for citizenship every month for potential Cherokee citizens of all sorts of descent, including Cherokee by blood and freedmen. So I think that number is just going to continue to grow.
And just before I turn it over to Vice Chair Murkowski, just for the other representatives of the tribes, whether over the table or in subsequent correspondence, I am going to try to get some fidelity on how many people we're talking about for each of your tribes and what percentage of your current membership that may comprise. I understand that is sometimes sensitive information, given that you are sovereigns, and so I want to be respectful of that. But I also think for decision-making purposes, we need to sort of understand not just the legal and moral and historical implications, but how many people are we talking about? And if it is a resource question, what it would cost to address. So just to let you know, those questions are coming, and I'm sensitive to the idea that maybe you don't want to give me incredible precision with a microphone on. Vice Chair Murkowski.
Thank you, Mr. Chairman. And I'd like to begin with a question to you, Assistant Secretary Newland. When Secretary Holland approved the Cherokee Nation's new constitution guaranteeing full citizenship, she did state very clearly, tribal self-governance is the best path forward to resolving internal tribal conflicts. We encourage other tribes to take similar steps. But as we have heard very clearly today, the treaties that the 5 tribes are under are very different, and therefore the obligations to the freedmen and their descendants are at question here, of course. So the question to you is, if the tribes treaty does not require it to extend membership to freedmen, what federal obligations does the federal government have to the freedmen and to their descendants? And I guess a follow-on to that would be if there are any administrative authorities that the Department of Interior possesses that could be utilized to address the concerns. You indicated that consultation has been underway and discussions about BIE and BIA, and the department has not determined yet how to move forward. But can you speak again to the federal obligation and also to potential administrative authorities?
Thank you, Madam Vice Chair. I want to make sure I'm understanding your question correctly. Are you asking if a freedman descendant does not have a legal right to tribal citizenship, at that point, what would the United States obligation
Correct.
Be?
What would the obligation be then to the freedmen and to their descendants?
Yeah. Thank you, Madam Vice Chair. If there's no legal right to tribal citizenship, it's not clear then that the United States would have a trust duty to any individual as though they were Indian or as though they were a tribal citizen.
And so what about any administrative authorities within the department to address some of the concerns that we've heard articulated today?
Thank you, Vice Chair. You know, this has been a difficult question for us to answer. I know some folks here in the room have views that these questions are clear, the answers are clear on their face, but in terms of how we would administer direct services to freedmen descendants, again, it's very difficult for us to put that into practice through the BIA because we're simply not set up or not constituted right now to make determinations about who would be a lawful or legitimate freedman descendant entitled to those services and who would not be. And so I guess the answer to your question is it's just not clear today what administrative capabilities we would have.
So let me ask yet probably another hard question, and that is a recognition that as sovereign parties to treaties, tribes clearly have an important role in interpreting the meaning of the treaties, but the United States is also the other sovereign party to the 1866 treaties that are signed by the 5 tribes. So the question would be, what role does the United States have to interpret and enforce the terms of these treaties as the other signatory? Probably not easy again for you to respond to.
Thank you, Vice Chair. They're all hard questions, which is why I think we're here in this setting today. Both sovereigns that are party to a treaty have a responsibility to fulfill the terms of the treaty, and also have a right to help determine the treaty and its meaning. I think the Cherokee Nation's journey here is a great example of the mix of diplomacy between the United States and the Cherokee Nation, but also the Cherokee Nation exercising its inherent sovereign powers through its own political processes and its own judicial process to resolve these questions without conflict or having an outcome imposed upon them from outside the nation. And so I think the United States has that ability as well as a sovereign party to the treaty. But, that can be, I think, the best way to resolve those is within the tribe and through the nation-to-nation relationship.
Assistant Secretary, hopefully this is very quick and very easy, but the Seminole Nation claims in their testimony that there's still some federal services that require the CDIB cards, the certificate degrees of Indian blood cards. These are including services that are provided by both BIA and Indian Health Services. Can you just share with me whether or not a CDIB card is a federal requirement for eligibility to access BIA programs and services?
Madam Vice Chair, typically we refer to a person's status as a tribal citizen or tribal member for the delivery of those services. And in most cases, and I believe with respect to all 5 of the tribes represented today, they perform the CDIB functions under contract with the BIA under their tribal government authority.
Thank you, Mr. Chairman. I'm well over my time. Thank you.
Thank you. Senator Lujan.
Thank you, Mr. Chairman, and thank you to you, Chairman Schatz, and to Vice Chair Murkowski for this important hearing to discuss these respective treaties of 1866. I want to thank each of our esteemed witnesses for taking time to be with us today, and for all of our constituents who are here as well to participate in person, and for everyone that is participating virtually as well with this important conversation. My first question is for Chief Hoskin. How has recognizing Cherokee freedmen as Cherokee citizens affected the Cherokee Nation?
Well, I think it's affected us in a positive way. I mean, Mr. Chairman, or Senator, there's something about living up to what we see at Cherokee Nation insofar as our 1866 treaty is an obligation. We think treaties are solemn promises. So that in and of itself, I think, does something for the Cherokee people. I also think that exploring a part of our history that we have frankly suppressed collectively, individually, and are now doing the opposite, embracing it, is good. Frankly, it's good for the United States to take some scrutiny of its own history. I can say that as a chief of the Cherokee Nation because the United States has suppressed Cherokee history collectively, individually. We have to look in the mirror and we have to recognize that we've done the same. embracing freedmen history, going into communities where many freedmen descendants live, for me as chief, I think it's made me a better chief. It is exposed me to some of the needs in that community that we need to work to meet. And so I just think it's been completely positive. I am not going to suggest that there hasn't been some difficulties in terms of our internal, debates and discussions about whether this is what the treaty meant. I mean, Cherokees are certainly noted for disagreeing from time to time. We have a great and vibrant democracy in the Cherokee Nation, and people have raised their voices. I think that's also been healthy. But ultimately, we respect the rule of law. We respect our ancestors, and our ancestors agreed 156 years ago that freedmen and their descendants should be considered people that have all the rights of Native Cherokees. Being able to say that is important. Lastly, Senator, when I come into this chamber or in any forum in which I am pressing the government of the United States to live up to its obligation, I do so as a chief of a nation that's living up to the obligations in that same document. It would be difficult for me, Senator, to come to this committee and press for treaty rights if I could not say to myself, we are living up to all of our obligations. That makes Cherokee Nation, insofar as our treaty is concerned, I think a nation in a stronger position than we would be had we not done that.
Thank you, Chief Hoskin. Assistant Secretary Newland, you mentioned in your testimony that Interior is continuing to review consultation feedback before it makes a decision on whether freedmen are entitled to enroll at Haskell Indian Nations University in Kansas and the Southwestern Indian Polytechnic Institute in New Mexico. Assistant Secretary Newland, although enrollment at BIA post-secondary schools is still under review, what are some direct federal services that freedmen with tribal membership are entitled to?
Thank you, Senator Lujan, for the question. So if freedmen descendants are enrolled as tribal citizens, then they are brought within the scope of our relationship between the United States and tribal nations, and would then be eligible for the services that the federal government provides to that tribe and its members.
Thank you for that. Ms. Van, yes or no, are Cherokee tribal members with freedman status able to receive every direct federal service and right that the federal government provides to tribal members without freedman status?
No.
My follow-up is, what federal services and benefits are they not eligible to receive despite having full tribal citizenship?
When the Stigler Act amendments were made in 2008, the Act of 1947, the language did not allow freedmen tribal members / freedmen citizens to inherit restricted land from their relatives or spouses of their tribes, and the land would retain its restrictions. One other thing is that freedmen tribal members and freedmen citizens are being treated differently when on the reservations when it comes to criminal cases. And again, I'm talking about the McGirt decision. So those are the two areas.
I appreciate that response, Ms. Van. And Mr. Chairman, my time has expired. I do have other questions I will be submitting into the record and to follow up with those that I've asked. Thank you for the time today.
Thank you, Senator Lujan. Senator Langford.